Just so everyone in the room knows, the hearing is being recorded and also live streamed. Now I can see you, Steve. So let me just do a microphone test with Steve. Could you say something to make sure we can hear you?
Good afternoon. Can you hear me?
Yes, very good. Thank you.
Good.
Wilson, could we do a microphone test with you? Can you say
Good
something?
afternoon, everyone.
Very good. Thank you. Okay. With that, I would, let's wait a couple of minutes. We're a little bit early still. We want to make sure our worldwide audience doesn't miss anything. In fact, while we're at it, can we do a microphone check with Brownlee and Lalonde as well?
Can you hear us?
Yes, thank you.
Okay.
This is Lalonde. Can you hear us?
Yes, you're a little bit faint, Team Lalonde. Don't know if you can bring the microphone a little bit closer to you.
No? Can you hear us a bit more clearly now?
Yes, I can. Is that better, Mr. Presiding Arbitrator? Can you hear them?
Yes, I can hear them fine. Thank you.
Okay.
Thank you.
So, with that, let me welcome you all to the 2019 FDI Moot All-African Final, featuring teams Brownlee and Lalonde. And I'll just very, very briefly introduce our three arbitrators, and I'll also ask them to say a little bit more about themselves before we actually commence the hearing. The presiding arbitrator is Mr. Joe Matthews. He's an international litigator and arbitrator based in Miami. He is joined by Mr. Stephen Finizio, an international lawyer and arbitrator based with Wilmer Hale in London, and Mr. Wilson Mbugwa, who is an academic focusing on international economic law, currently doing research in Salzburg, but otherwise based at the University of Hong Kong. And with that, I will turn it over to you, Joe.
Thank you, Chris. Good afternoon, everyone. It is a great pleasure to serve with Mr. Finizio and Mr. Mbugwa as your panel for the final competition. Congratulations to you all for getting to this stage. The three of us are looking forward to this very, very much. Because you have gone through the process of presenting by video conference, and the three of us have done some testing, but we haven't yet conducted, or at least I have not yet participated as an arbitrator. I think I will repeat a couple of things you probably know, but the first thing is that, and probably the only primary rule is, if you see either of my colleagues or I go like this, it means that we would like to ask a question or to express something. Beyond that, I don't think there are significant rules. I will, after I've allowed or I've asked my colleagues to say a little bit more about themselves, I will ask you for the time estimates and how you're allocating your time. I will try my best to keep track of the time by using a timer on my cell phone. That said, I don't think you need to know too much more about me. I've been in Miami for 45 years. I've met many, if not most, of the LLM students at the University of Miami's International Arbitration Program over the past 10 years, and have enjoyed very, very much participating both in those classes and in the arbitration competitions that have taken place over those years. Mr. Finizio, let me start with you. If there's anything more that you would like to describe, please.
Thanks, Joe. I just would say that I am also, first of all, congratulations to the two teams for being here now. I'm very much looking forward to this. I also want to say congratulations to the organizers, because the problem, I think, is a particularly good one, and one that fits some of my personal interests in my practice. I am in private practice, as Chris said. I am based in London, but like Joe, I'm an American lawyer. I focus on both treaty arbitration and commercial arbitration as both the counsel and as arbitrator, but I do have a particular interest in freedom of expression issues, and I think we've got a very finely poised question here that I'm really looking forward to hearing the parties on. So thanks, and I'm looking forward to it.
Thank you, Steve. Wilson, would you like to say a little bit more about your background?
Yes, thank you very much. And congratulations to the team for making it to the final. I know everyone is excited. And just a little bit, I'm based in Salzburg at the moment, and you would bear with me the noise. There are concerts being held outside, so bear with me. And I'm looking forward to hearing all the presentation. And prior to turning to academia, I practiced law in Nairobi, and I was focusing on litigation and commercial litigation. Thank you.
Okay, I guess that leads us to one more of the rules that I'm sure you all are familiar with, and the three of us will try our best to accomplish, and that is to mute our own speakers whenever we are not speaking, though I'm sure we would all enjoy the music from Salzburg. With that, I would like to invite first Claimant's Counsel, if you can please give me an indication. Well, let me start with Respondent's Counsel, since in order we're going to go with the provisional remedies issue first. If the Respondent's number one speaker, is that going to be Ms. Mavati?
The number one speaker is Michael Wambua.
Okay. My apologies. I just have those reversed. Then if I could ask you to please indicate how you would like your time allocated, and we will not be quite as rigorous in our timekeeping this round, I suspect, but I will try to let you know when the time is running. I'm going to try to keep track of it. So how much time and how would you allocate it, sir?
I will be taking 17 minutes to address issues A through to C. And my co-counsel, Ms. Joy Mbati, will take 18 minutes to address the merits, that's issues D to E. We will reserve 2.5 minutes for rebuttals and 2.5 minutes for rebuttals.
Thank you very much. Now, counsel for claimant, who will be speaker or claimant number one?
Myself. My name is Grace Zawadi.
Yes, ma'am. And can I ask you if you would please tell us how you want to allocate your time?
I will spend 25 minutes addressing the tribunal on the jurisdictional matters. Mr. Salaton Lemayan will then, in 18 minutes, address the merits of the case. And we reserve 2 minutes for rebuttal and rebuttal.
Okay. I don't know if I will get that right, but I will certainly do my best. Okay. With that, I am all.
Just a clarification.
Sure.
So the claimants reserve 2 minutes for rebuttals and rebuttals, which means a minute for rebuttal and 1 minute for rebuttals.
Is that correct?
Yes. First counsel will use a minute to rebut, and second counsel will use a minute to rebut.
Okay, I think I have it. Again, I will try my best, and we will probably not be rigid, but please do keep track of your own time. And with that, if there are any other preliminary matters, please raise them. If not, then in accordance with the order by the tribunal, I will invite respondent to make presentation regarding issues A, B, and C.
Thank you. Mr. President, members of the tribunal, good afternoon from this side of the world. My name is Michael Wambua, and I appear alongside Ms. Joy Mbati. Together, we appear on behalf of the respondents in this matter, the government of Tyria. This tribunal has granted us 40 minutes of its time to present our pleadings. Of the 40 minutes, I shall take the first 17 minutes to address the tribunal on the provisional measures and the jurisdictional questions. Ms. Joy Mbati shall address the tribunal in the 18 minutes thereafter on the merits. This dispute revolves around a former EXID member that seeks to preserve political serenity within its territory, especially given the social media era. It brings to the fore the tension between denunciation and consent under the EXID Convention. Against this background, we make the following submissions. 1, that this tribunal should recommend the provisional measures sought. 2, that this tribunal should find that it does not have the jurisdiction to entertain this particular claim because Tyria denounced the EXID Convention. And 3, that this tribunal should find that it does not have the jurisdiction to entertain this particular multi-party claim. Under the first claim of argumentation, our heads of argument shall be A, that this tribunal has the prima facie jurisdiction to recommend the provisional measures. B, that there are rights and those rights are in need of preservation. And C, that it is necessary and urgent to preserve those rights. Provisional measures are extraordinary procedures that are recommended by an exit tribunal where it seeks to preserve the rights of a party, and in the absence of such preservation, the rights of a party would be jeopardized. In order to recommend provisional measures, a tribunal is to be guided by Article 47 of the Exit Convention, read together with Rule 39(1) of the arbitration rules. Together, they provide for a three-part test. And the test is, A, does the tribunal have prima facie jurisdiction? B, are there rights and are those rights in need of preservation? And C, is it necessary and urgent to preserve those rights? This is a conjunctive test, and therefore we shall address each tier of this test. With regard to the prima facie jurisdiction, the exit tribunal in Occidental Petroleum versus Ecuador in 2007, when faced with the question of provisional measures, addressed itself to the question of prima facie jurisdiction by making an objective assessment of the facts before it. The objective assessment that was made in that dispute was, are the parties to the dispute members of the Exit Convention, or are they nationals of members of the Exit Convention? If this tribunal is to make an objective assessment of the facts before it, Tyria is a former member of the Exit Convention, and the claimants in this dispute are nationals of a member of the Exit Convention. Secondly, with regard to the rights, I wish to guide the tribunal to page 36 of the record at paragraph 1. The right in need of preservation is that of non-aggravation of the dispute. This is a right that has been recognized to be a self-standing right. This means that it does not necessarily need to be tied to the subject matter of the dispute in order for a tribunal to recognize and to preserve it in a case of provisional measures. We submit before this tribunal that the right to non-aggravation of the dispute is at the risk of being jeopardized before the case in this tribunal. The right to non-aggravation was recognized in Burlington versus Ecuador by an exit tribunal in 2009 to be a right that is self-standing. And that means the tribunal recognized that there are instances whereby a party may act in such a manner that is retaliatory, and the retaliatory measures are not connected to the subject matter. In such instances, a tribunal can recommend provisional measures despite the retaliatory acts not being tied to the subject matter.
Can I ask a question? You're starting to delve into the standard, but can you tell me what your position is as to what the aggravation is here? What is the claimant doing that is creating an aggravation that's relevant to the standard you're describing?
Thank you. That takes us to our submission on the aggravation that is before this dispute. The aggravation is that there is evidence that the claimants have engaged a public relations firm to expedite the bilateral resolution of this dispute.
Well, can I ask you to explain that? Public relations campaign, how is that expediting the resolution of the dispute? What's the connection between the campaign and something that either aggravates the dispute or affects this tribunal?
The connection is the expedition of the bilateral resolution of this dispute we submit is in the form of instigating and promotion of propaganda. There is evidence that the claimants have engaged in a public relations firm, and we wish that this tribunal infer that because of this evidence, the claimants are responsible for some of the case materials that have been presented selectively in the public.
I guess I'm focused on the question of what aggravation means. You're describing steps they've taken to publicize their position, but aggravation means more than publicizing their position. What is aggravating about what they've done?
the manner of publication is selective to favor their position and paint Tyria in a bad light. It therefore worsens this dispute because the claimants are selectively publicizing the case materials. For example, at page 37 of the record, paragraph 5, the words by Tyria that the freedom of expression in Tyria is hypocritical were taken out of their context, and after being taken out of their context, used in such a manner to publish the claimant's case favorably to them, and therefore at the detriment of Tyria's image. This type of propaganda is likely to affect the resolution of this dispute, despite it not being connected to the subject matter.
Can you explain, though, why is it likely to affect the outcome? Is it because this tribunal is the one who will decide the outcome? How is that sort of publicity campaign likely to affect us? And is that the standard that you were describing earlier?
No. The standard we were describing earlier, and which our submissions are on, is that the fact that the claimants have engaged in a public relations firm and there is propaganda being spread is a self-standing right and therefore does not need to be connected to the subject matter, which essentially means that the respondents need not prove to this tribunal that the award that there will be difficulty in rendering the award should the tribunal not find a link between the claimant's conduct and the provisional measures sought or the right that is being sought. We therefore submit that it being a self-standing right, the tribunal only need to be satisfied that the conduct of the claimant is aggravating the dispute. With regard to the third tier of the test, we submit...
If I may too, forgive me, but just in follow-up to my colleague's question, is it your position that it is a freestanding right of the government to not be criticized? Is that the right that is freestanding that we're being asked to impose a provisional remedy to protect?
No. The right we are seeking this tribunal to implement is that the claimants should not publish case material selectively or promote publication of case material selectively in a manner that takes the words such as in paragraph 5 of page 37 out of their context. This taking out of their context and selective publication is what the government of Tyria seeks this tribunal to preserve. With regard to the necessity and urgency, we invite the tribunal to recall the decision in Mafezini versus Spain by an exit tribunal in 2009, which recognized that what is necessary is that which causes irreparable harm. And therefore, that which causes irreparable harm means that there are some form of damages there are some forms of harm rather, which can be repaired by damages, but there are other forms of harm that despite payment of damages will not be repaired. We submit before this tribunal that the harm that is to be occasioned before Tyria is irreparable because Tyria is a country that is emerging from civil unrest. The state of Tyria is one where there has been political tension, and the claimant's conduct, if allowed, would lead to the resurgence of political tension and civil unrest in Tyria. Should this propaganda continue, there is the likelihood that lives will be lost. That is the irreparable harm to be occasioned on Tyria, and that is the harm we seek this tribunal to preserve against. As to urgency, what is urgent is that which needs to be dispensed with before an award can be rendered. We submit before this tribunal by the fact that there is a possibility of loss of lives. This cannot wait for an award to be rendered, and therefore the tribunal should find it necessary and urgent, and therefore recommend the provisional measures sought.
May I, forgive me for one more question. Is it the case then that you believe that the campaign and the PR activities that have been taking place since this proceeding commenced are inciting riots, not just what was published before the blocking? Is that the position of the government?
The position of the government is that there's a likelihood, given Tyria's history, that if propaganda is to be spread within Tyria, then the two major ethnicities, that is Tatia and Minya, may go back to the civil unrest that they had experienced prior to 2012. We ask this tribunal to guard against this. With regard to the second limb of our submissions, we submit that this tribunal should find that it does not have the jurisdiction to entertain this claim because Tyria denounced the Exit Convention. Our heads of argumentation shall be that Article 72 provides for mutual consent and that Article 71 is not applicable in this present dispute. Consent is the hallmark of arbitration. It is therefore crucial that any arbitral tribunal that is seized of a dispute satisfy itself that the parties to the dispute have consented and that it has the jurisdiction to entertain the claim. Such satisfaction is to be arrived at by looking at two separate international legal instruments. The first is the bilateral investment treaties between the parties, and the second is the Exit Convention. I shall go directly to the crux of this matter, which is the Exit Convention. At Article 72 of the Convention, it provides for the rights and obligations of a denouncing exit member. It provides for the rights and obligations of Tyria. And it provides that notice by Tyria shall not, pursuant to Article 70 or 71, shall not affect the rights or obligations of Tyria arising out of consent to the jurisdiction of the center, provided that such consent was given before the notice of the denunciation was submitted to the depositary. It is our submission that the consent referred to in Article 72 is mutual consent. Consent by the parties to the dispute, consent by Tyria, and consent by the claimants. This is because if this tribunal is to interpret Article 72 based on Article 31 of the Vienna Convention on the Law of Treaties, which requires a good faith interpretation based on the ordinary meaning of the words and in their context, then it would arrive at a finding that Article 72 requires mutual consent. What is the context of Article 72? The context is the Exit Convention, where the Exit Convention makes reference to consent arising out of or consent to the jurisdiction of the center. The reference is consent by the parties to the dispute. Examples of this can be at paragraph 6 of the preamble, at Article 25(1) of the Exit Convention, Article 26, Article 36, and Article 48(5). Notably, there are instances where the Exit Convention only makes reference to consent and does not qualify it by use of the reference by the parties to the dispute. However, such instances, such as in Article 25(3), only contain negative prescriptions, which require unilateral consent. Where reference has been made in the Exit Convention to the consent to the jurisdiction of the center, it requires mutual or matching consent. And therefore, a reading of Article 72, which requires mutual consent, would invite this tribunal to consider three critical dates. The first, which is a set, is the date which Tyria gave the standing offer in the bilateral investment treaties. As per page 48 of the record, paragraph 2, the relevant date is 10th September 2000 and 25th May 2001. The second critical date is when this standing offer was accepted by the claimants by filing their request for arbitration. Their request for arbitration was filed on 29th June 2018. What is the third and most critical date? As per Article 72, that becomes when the notice was served to the depositary, and that is 5th January 2018. Because the claimants submitted their matching consent after the notice had been submitted to the depositary, then the rights or obligations of Tyria have been affected, and therefore this tribunal should find that it does not have jurisdiction.
Can I ask a question? I think you probably recognize that this is a somewhat unappealing argument that you're making, in the sense that, as you say, a standing offer was provided by the state. The investor then invests in the state, and under your approach, the state can unilaterally, post-investment, withdraw its consent to arbitrate without any notice, with immediate effect, leaving the investor who has invested based on that standing offer without a remedy under the BIT. And in that light, I'm wondering whether you can explain why that would have been the intent of the convention and why we should ignore the language in Article 71 of the convention that at least seems to create a buffer zone to avoid the sort of unprotected right that we see under your scenario.
I see that my time is well spent, and I seek 3 minutes to answer the question and conclude our submissions. With
You may proceed. I will add another minute or two. Go ahead, proceed, answer the question, and then proceed with your presentation.
Thank you. With regard to the first question, we submit before this tribunal that in AAPL versus Sri Lanka, an exit tribunal in 1990 recognized that there are various forms of accepting the consent requirement in Article 25. Consent in writing can be given the minute an investor makes an investment in a state. And therefore, a prudent investor, the minute they make an investment in a state, can accept the standing offer in the bilateral investment treaty. Had the claimants in this matter accepted the standing offer the minute they made their investment, that is, had they been prudent to do that, then that essentially would mean that we would not be making an Article 72 argument, as the consent, the matching consent, would have been given before the notice of denunciation. Because the matching consent was given after, then this tribunal should find that it does not have the jurisdiction. With regard to the second question, Article 72 is a modification of Article 71. It modifies it in 2 ways. The first is that it introduces a different date, a different critical date for denunciation. The critical date becomes that of receipt of the notice and not necessarily that of the 6-month waiting period. The second way the modification applies is that Article 72 provides for the rights or obligations of a state arising out of consent to the jurisdiction of the center. Therefore, Article 72 regulates states as parties to a dispute, whereas Article 71 regulates states as members of the exit convention. And therefore, this being a dispute before a tribunal, the relevant article for application is Article 72.
What is the practical effect of that distinction? What is the benefit to the 6-month period as a member of the convention? And why would that be prioritized over the rights of investors who've invested pursuant to an offer of jurisdiction, so that there would be a reason to have that sort of difference that you've just described?
The effect would be that this tribunal would be recognizing that a prudent investor needs to accept the standing offer the minute they make an investment. And over and above this, the tribunal would be recognizing that there are certain rights or obligations that arise out of consent to the jurisdiction of the center, such as the rights and obligations under Article 36, 37, 41, and 44 of the Exit Convention. And there are certain rights and obligations arising out of a state being a member of the Exit Convention, such as in Article 4 to 7 of the Exit Convention, Articles 14, 18, and 24.
I'll let you finish. Never mind.
Oh, no, I didn't mean to stop that at all. Your time has expired, but please, if you have another question, it's not a problem.
One relatively simple question then is, I wonder, other than the 1990 precedent or case that you described, do you have any other authorities to support this notion of standing consent?
Yes. Our line of argumentation has found support by previous exit tribunals, such as recently in Fabrica versus Venezuela in 2017, where an exit tribunal recognized that a standing offer must be accepted before the notice of denunciation is submitted to the depositary.
Okay, thank you.
Counsel, please take 30 seconds on the multiple parties issue, and then we're going to wrap up your direct.
Thank you. We submit that this tribunal should find that it does not have the jurisdiction to entertain this particular multi-party claim. The question of multi-party claims not being dealt with under the Exit Convention but having been dealt with by previous exit tribunals, this tribunal should be guided by the manner in which previous exit tribunals have decided over multi-party claims. In Abaclat versus Argentina in 2011, and in Ambiente versus Argentina in 2013, in admitting multi-party claims, the exit tribunals in those disputes looked at the bilateral investment treaty in the dispute, that is the Argentina-Italy BIT, and recognized that because the BIT provided for investors in the plural bringing a dispute before an exit tribunal, then the BIT and the parties anticipated multi-party claims. To contrast this with the dispute before this tribunal, the Article 9, which provides for the dispute resolution clause, provides only for a national, in the singular, bringing a dispute before the exit tribunal. This is contrasted with Articles 6 to 8 of the Bilateral Investment Treaty, which uses the term nationals in the plural. It shows that in the dispute resolution clause, the parties only provided for a national in the singular bringing a dispute, and therefore only anticipated for a single party arbitration.
Okay, let's call that the extension. Counsel on the other side, if it's necessary, we will accommodate as well. Let's turn to, please, the position of claimant on these three issues that have been discussed so far.
Greetings, Mr. President, honorable members of the tribunal. My name is Grace Zawadi, first counsel representing the claimants. With me is Mr. Salaton Lemayan, second counsel, and together we are Team Lalonde representing the claimants. I will, in 25 minutes, address the tribunal on the jurisdictional matters of this case, in which it is the claimant's submission, A, that this tribunal should not grant the provisional measures that are sought by the respondent state, B, that the tribunal has jurisdiction over the dispute in spite of Tyria's denunciation of the ICSID Convention, and C, that the tribunal has jurisdiction over the multi-party arbitration claim before it. Mr. Salaton Lemayan will then, in 18 minutes, address the tribunal on the merits of the case, in which it is the claimant's submission, D, that the respondents violated the fair and equitable treatment standard and unlawfully and indirectly expropriated the investments of the claimants. And on issue E, we submit that the compensation that is sought by the claimants is not speculative, and that the discounted cash flow method is the appropriate method for valuation of damages in this dispute. We reserve 2 minutes for rebuttal and surrebuttal, and if there are no preliminary questions, I would like to proceed to my arguments. The dispute before the tribunal has been occasioned by the respondents' unreasonable, disproportionate, and discriminatory measures of blocking the claimant's social media platforms. The respondent intends to extend its control over the claimants by means of provisional measures. We thus submit on issue A that this tribunal should not grant the provisional measures that are sought by the respondent state. To substantiate this submission, we shall make 3 arguments. First, that the requirements of Rule 39 of the ICSID arbitration rules have not been satisfied. Secondly, that in any case, the respondent's rights in this dispute are not at risk of infringement. And lastly, that the necessity, urgency, and proportionality requirements in this dispute have not been satisfied. I proceed to the first limb of argument that the requirements of Rule 39 of the ICSID arbitration rules have not been satisfied. Rule 39 of the ICSID arbitration rules governs the application of Article 47 of the ICSID Convention that provides for provisional measures. The mandatory nature of the word shall that accompanies the requirements of Rule 39 implies that the satisfaction of these requirements is requisite to a successful request for provisional measures. Rule 39 requires a party seeking provisional measures to specify the rights that they seek to be preserved, the measures that they seek from the tribunal, and the circumstances that require such measures. The respondent state in this case has cited highly hypothetical situations as the circumstance that requires provisional measures. We refer the tribunal to page 38 of the record of disputes. At paragraph 9 of the request for provisional measures, in which the respondent has confirmed that the World Expo 2025, or rather that the decision on the country that will host the World Expo 2025 is yet to be made. At paragraph 10 on the same page, the respondent has confirmed that the 5-year and 10-year bond issuances to which they have referred in their request for provisional measures are also yet to be made. This means that the respondents have premised their request for provisional measures on circumstances, or rather on rights that they do not actually own at the moment. And as was opined by the ICSID tribunal in the case of Emilio Maffezini versus the Kingdom of Spain, the issuance of provisional measures cannot be justified by a party's expectation of future success. Further, at paragraph 9 on the same page, the respondents have termed the political situation in the Republic of Tyria as volatile. We submit that this is not an accurate representation of the political situation in Tyria in the recent past. We refer the tribunal to page 62 of the record of disputes. At paragraph 5 of procedural order number 2, in which it has been confirmed that there has been a general de-escalation of political tensions in the largest cities of Tyria, where the claimant's actions would have the most impact. And at paragraph 13, it has been confirmed that the media articles that have so aggrieved the respondents are still in circulation in Tyria. This means that the nature of the article is not one that would instigate a civil war. In addition to citation of hypothetical and speculative situations, the respondents have also not specified the rights that they seek to be preserved. As a matter of fact, paragraph 1 of the request for provisional measures in this case, on page 36 of the record of dispute, is almost identical to paragraph 1 of the request for provisional measures in the case of Amco Asia versus Indonesia. In that case, the request for provisional measures was denied, and the parties' failure to cite specific rights that they seek to be preserved mentioned as one of the reasons for such denial. Having established that the requirements of Rule 39 of the ICSID arbitration rules have not been satisfied, I now proceed to the second limb of arguments that in any case, the respondents' rights are not at risk of infringement. To begin with, it is well within the claimant's rights to employ a media strategy. Meg Kenya, the Secretary General of ICSID, and Aissatou Diop jointly authored an article titled Use of Media by Counsel in Investor-State Disputes, in which they correctly observe that numerous tribunals have found that a party's employment of a media strategy cannot amount to aggravation of a dispute. This is, yes.
Excuse me, may I ask you a question, please?
Yes.
In Ms. Kinnear's article, or in the case that you just referred to, was there anything like the risk of civil unrest, violence, and potential loss of human life that was at issue?
Thank you, Mr. Abitita, for your question. In the article that Meg Kenya authored was a commentary generally on the ICSID arbitration decisions pertaining to parties' employments of media strategies. However, in the case to which I have referred, there was no risk of civil unrest, but we submit that in this case, the risk of civil unrest is not as it has been represented by the respondent states. As I have earlier submitted to this tribunal, at paragraph 13 of the procedural order number 2, on page 63 of the record of disputes, paragraph 13 of procedural order number 2, it has been confirmed that the media articles that have so aggrieved the respondent are still in circulation in Tyria. But at paragraph 5, the political tensions in Tyria are still de-escalating in spite of the circulation of the media articles, which goes so far to say that the nature of the articles is not one that will instigate a civil war. I proceed with my earlier argument that in any case, yes.
Before you do, let me ask one more follow-up on that. How do we know whether, I mean, aren't we running the risk that that this public relations campaign and before we're able to enter an award resolving these issues could foment a great deal of violence?
Thank you, Mr. Arbitrator. It is the claimant's position that the nature of the media articles will not be one that will instigate a civil war. I proceed with my argument. So in McKinney's article and Isatudio, they correctly observe that numerous tribunals have found that a party's employment of a media strategy cannot amount to aggravation of a dispute. This is because in most investor state disputes, there is no requirement of confidentiality. They enumerate 3 possible sources of such a requirement: the relevant treaty or contract, the relevant arbitration rules, and the relevant procedural rules. In this case, none of the possible sources of such a requirement point to a requirement of confidentiality on the parties to the dispute. In any case, we refer—
May I ask a question?
Yes.
Let's assume that there's not a duty of confidentiality.
Yes.
I think I hear a complaint by the claimant about the scope of the relief requested. And I'm wondering, even if there isn't a duty of confidentiality, do we as a tribunal have the authority to regulate what you say about the contents of the arbitration if we are concerned that it might inflame a dangerous situation? Putting aside how dangerous the situation is, which is something we can't assess, if we have a concern about that, do we have the authority to regulate not everything your client says, but what your client says about materials submitted within this arbitration?
Yes, Mr. Arbitrator. This tribunal has the authority to regulate the kind of information that is left to the public by the claimants in this case. But that brings me to our second submission, that in any case, the media campaign was not directed at the subject matter of this dispute. We refer the tribunal to page 36 of the request for provisional measures. At paragraph 3, I apologize, page 36 of the record of dispute, at paragraph 3 of the request for provisional measures. You will observe that the titles of the media articles that have so aggrieved the respondent pertain to civil liberties of freedom of expression and freedom of the media, and yet the subject matter of the dispute before this tribunal is violation of the fair and equitable treatment standard and expropriation of the claimant's investments. The respondents have also lodged— Yes.
I'm sorry. Forgive me for cutting off. But isn't that at the heart ultimately of the fair and equitable treatment and the expropriation issue as well? Isn't the position of the government that some nations are too fragile to have the same level of open and contentious debate that may be appropriate or used in other nations?
Thank you, Mr. President, for your question. That may be the opinion of the respondents. However, the claimants do not share the opinion. The claimants are of the opinion that people should have the civil liberties that accrue to them by the virtue of them being human. And for that reason, the claimants have employed a media campaign in order to attain the results that they think are desirable in the Republic of Tyria, and this is well within their rights.
So if I may follow up on the point that we were talking about before,
Yes.
why would the claimant object, or what basis could the claimant object to if we were to issue a provisional measure that said the claimant is entitled to make whatever political or human rights points it wants to make in the media or otherwise, but it's not entitled to use materials from this arbitration in doing so? What would block us or prevent us? What reason should we not do that?
Thank you, Mr. Arbitrator, for your question. In responding to it, I will refer the tribunal to page 37, paragraph 5 of the request for provisional measures, whereby the excerpt of the case material that was forwarded by the respondents that has aggrieved them pertained was, or rather the misleading phrase that was under the excerpt made by the claimants was, freedom of expression is hypocritical. Thus, all the efforts of the claimants have been directed towards the civil liberties of the citizens of the Republic of Tyre. However, if the tribunal is of the opinion that case material that has been produced by an opposing party should not be published, the claimants are ready to concede. Thank you, Mr. Arbitrator. I now proceed to the third limb of argument, that the necessity, proportionality, and urgency requirements have not been satisfied. We submit that the necessity, urgency, or rather, in the case of Quiborax versus Bolivia, it is found that for the necessity and urgency requirements to be satisfied, there has to be an imminent danger of irreparable harm before a decision is made on the merits of the case. We submit that the harms that have been foreseen by the respondent state are speculative and hypothetical, and in any case, they are reparable by means of monetary damages. The proportionality requirement has also not been satisfied, given that even in the event that the tribunal issues the provisional measures, it cannot be certain that this matter of international interest will no longer be addressed by international media houses. And yet the claimants will be precluded from their right to contribute to this matter of civil liberties that they are interested in.
May I stop you for a moment? I apologize. It goes back to a little bit earlier comment you made. How would we as a tribunal compensate the respondent government if we later conclude that your activities, your public relations campaign caused them harm? Do we have the authority to award damages to them for your conduct?
Thank you, Mr. Arbitrator, for your question. In the event that at the merit stage of the case, the tribunal, or rather later in the case, the tribunal finds that the claimant's actions later resulted in the harms that had been foreseen by the respondent, this tribunal can add the damages that will accrue to the respondent to the award that will be given to the respondent at the merit stage of the case.
Go ahead and proceed.
Thank you, Mr. President. I have come to the end of my submission on issue A of the disputes. I now proceed to issue B, in which it is the claimant's submission that this tribunal has jurisdiction over the dispute in spite of Tyre's denunciation of the ICSID Convention. To this effect, we shall make two arguments. First, that the arbitration clauses of the relevant BITs constitute mutual consent and not a mere offer to arbitrate as has been represented by the respondents. And under our second argument, that is an alternative argument, we submit that consent in this dispute was perfected before Tyre's denunciation of the ICSID Convention took effect. Under the first argument, we submit that the arbitration clauses of the relevant BITs in this case, which is the Tyre Novanda and the Tyre Kitoa BIT, constitute mutual consent and not a mere offer to arbitrate as has been represented by the respondents. It has been the respondents' contention that the arbitration clauses of the relevant BITs constitute a standing offer to arbitrate. We disagree with this position, and submit in its stead that the arbitration clauses of the BITs in this case constitute mutual consent that satisfies the requirements of Article 25, Sub-Article 1 of the ICSID Convention. Standing offers imply that there is necessity for secondary action by the claimants, or rather by an aggrieved investor, for jurisdiction ration voluntatis to be established. The kind of arbitration clause that has been referred to by the respondents can be found at Article 12, Sub-Article 2 of the Canada-Venezuela BIT, in which it is provided that for jurisdiction ration voluntatis to be established, a claimant must have previously consented to the provisions of the arbitration clause under the Canada-Venezuela BIT. That is why the ICSID tribunal, while arbitrating the case of Risoro Mining versus Venezuela, found that the arbitration clause under the relevant BITs constituted a standing offer to arbitrate and not mutual consent. This must be distinguished from the arbitration clause in this case. We invite the tribunal to consider the provisions of Article 9, Sub-Article 3 of the relevant BITs at page 56 of the record of dispute. In which each contracting party has provided unconditional consent to ICSID arbitration. Emphasis added on each contracting party and unconditional consent. This constitutes mutual consent and not an offer to arbitrate made by the Republic of Tyria. In the case of Inskale Insaat versus Turkmenistan, arbitrated by the ICSID tribunal in the year 2016, it was found that it is common and often harmless to refer to the arbitration clauses of BITs as offers to arbitrate. But the term standing offer to arbitrate is conceptually inaccurate and legally incorrect. The arbitration clauses under BITs constitute mutual consent that have binding effect on a host state, even without further perfection by the claimants. This rationale was later applied by Mr. Krista Soderland in his separate opinion of the case of Blue Bank versus Venezuela, in which he found that the jurisdiction of the ICSID tribunal would not be affected even in the event of a denunciation where parties have given mutual consent under BITs and the BITs are still in force. Yes? Can I
ask a question? I guess I'm confused by the reference, the use of the phrase mutual consent. I understand the potential argument that there is an irrevocable consent by the state, but where does the mutuality come from? When has the investor given its consent, and it has an option not to pursue this as a way to protect its rights? So when has the investor given its consent? Mutuality in the BIT would be among the contracting states to the BIT. So I'm confused by the use of mutuality.
Thank you, Mr. Arbitrator, for that very important question. It is the claimant's submission that the Tyria Kitoa BIT and the Tyria Novanda BITs constitute, especially the arbitration clause, constitute an agreement of Tyria and the other contracting parties on how the disputes between Tyria and a national of the other contracting party, as can be found at sub-article 1 of the article 9 of the relevant BITs. So the arbitration clause has been directed at the resolution of disputes between Tyria and a national of the other contracting party. Thus, our argument basically is that the states of the investors represented them under the arbitration clauses, and this satisfies the requirements of the jurisdictional requirements of the ICSID Convention.
If the state wanted to denounce that obligation, when does that denunciation become effective?
Thank you, Mr. Arbitrator. If the Republic of Tehran intended to denounce its obligation to present any disputes before the ICSID tribunal, it will have to wait until the survival clause of the relevant BITs have come to an end. This can be found through reference to the Travaux Préparatoires of the ICSID Convention, Volume 2, Part 2 of the ICSID Convention, at paragraph 57 and paragraph 58, in which Mr. Aaron Broches addressed a situation in which a contracting state to the ICSID Convention denounces the ICSID Convention, and yet it had already in an arbitration clause provided that it has consented to arbitration under the ICSID Tribunal. Mr. Aaron Broches opined that in such an event, even after denunciation of the ICSID Convention, because of the BITs that are still in force, the state that has denounced the ICSID Convention will still be bound by the arbitration clause in the BITs.
Thank you.
We're getting close, but why don't you move on and take a few minutes with the multi-jurisdictional, or excuse me, multi-party issue if you'd like to.
Thank you, Mr. President, for your guidance.
Take your time.
I proceed to issue C, in which it is the claimant submission that this tribunal has jurisdiction over the multi-party arbitration claim before it. The respondent state has contended before this tribunal that it has not given consent to multi-party arbitration claim because the provisions of the arbitration clause under the relevant BITs are in singular terms. There was a similar rationale in the case of Alemany versus the Argentine Republic, and the tribunal held that it is not relevant whether singular terms or plural terms were used in a BIT. What is relevant is the scope of consent that has already been given by the contracting states. In that case, there was unconditional consent to ICSID arbitration, and the tribunal found that unconditional consent gives a scope that is wide enough to cover multi-party arbitration. We submit that under Article 9, Subarticle 3 of the relevant BITs in this case, there is also unconditional consent that gives a scope that is wide enough to cover multi-party arbitration, and thus the tribunal has jurisdiction in spite of, yes.
Oh, I'm sorry. I didn't mean to cut you short. I wanted to let you continue. I have something, it may be a practical question. It may not be appropriate to ask, but does the tribunal have the authority to grant relief in favor of one of the claimants and deny it to the other claim, to another claimant?
Thank you, Mr. President, for your question. It is well within the tribunal's powers to decide the kind of awards it will wish to grant to the claimants in this case. That will mean that it will basically be handled like a consolidation claim, and it is well within the tribunal's powers.
Any other questions from my colleagues? If not, if you want to take a moment, or if you've already summed up, feel free. I don't hear any other questions from my colleagues, so have you completed your submissions for now?
Yes.
Okay. Let's see. I believe that respondent reserved 2.5 minutes. Am I correct about that?
Yes.
Okay. Feel free to start. Thank you.
Mr. President, members of the tribunal, we have 3 key rebuttals arising from the claimant submissions. The first, with regard to provisional measures, they have put forth before this tribunal that no specific right to be preserved was brought before the tribunal by the respondents. What is problematic about this is that the respondent stated that the right to non-aggravation of the dispute is what is in need of preservation. Over and above this, they stated that Tyria is not in a volatile situation. Pages 48 of the record and 61 show that Tyria is in a volatile situation. The paragraph they relied on, that's paragraph 5 of procedural order number 2, to show that the situation has quelled down in Tyria, only shows that the government has acted out of abundance of caution, and the situation has quelled down because of the actions of the government, and not because of the claimant's act or failure to act. Over and above this, they relied on AMCO. The problematic reliance on AMCO is that AMCO was a case in 1983, before the vast social media era, and it did not take into account the loss of lives. The harm to be occasioned was economic and not the loss of lives. Secondly, with regard to their jurisdictional arguments, the claimants have argued that the bilateral investment treaty constitutes consent by the parties to the dispute. Article 25 of the Exit Convention requires consent by the parties to the dispute. That is the claimants and the respondents in the dispute. This means it does not require consent by the states. The states are the ones that give consent in bilateral investment treaties. Their emphasis of contracting party in Article 9 guides this tribunal because it's each contracting party as a state and not as an investor. Over and above this, their reliance on Bloomberg versus Venezuela is problematic because Mr. Sunderland, in his dissenting opinion, recognized the offer and acceptance concept. Lastly, on when denunciation becomes effective, there
We seem to have lost the.
Yes, we seem to have lost the connection with
To Brownlee.
I would suggest that we simply wait a couple of minutes to see if they can reconnect and then continue, if that's all right with the tribunal.
Yep, that'll work. Do you have an ability to reach them and let them know?
I'm sending them an email, so I
That's-
hope that will work.
Okay, they're moving, I can see. Actually, both of them are now. Have council rejoined us now? Brownlee?
yes.
Okay, and Lalonde, have you also rejoined us? Yes, okay. I think it was, you were nearing the end, counsel for respondent, but why don't you take another 30 seconds or so to complete your rebuttal, and then we'll move to Lalonde's rebuttal of 1 minute.
Thank you. Our last rebuttal was with regard to multi-party arbitration. Article 42 of the Exit Convention requires that the tribunal apply the law that has been agreed by the parties to the dispute. The law is the bilateral investment treaty. It only provides for what is a single party arbitration. The claimants have not put forth any test to be used by this tribunal in admitting the multi-party arbitration, and in the absence of such submission, the tribunal should be guided by Article 9 of the Bilateral Investment Treaty. Thank you for your time.
Thank you very much, counsel. I believe that counsel for Lalonde has reserved one minute for rebuttal. If you'd like to proceed, please do.
Thank you, Mr. President. The respondents have rather contended before the tribunal that they have specified the rights to be preserved, but our submission was that under their request for provisional measures, there is no such specification. Further, they have contended that Mr. Sutherland, in his separate opinion, was a proponent of the offer acceptance means of interpretation, but he was not of that opinion, as can be found from paragraph 46 of his separate opinion to paragraph 56 of the same opinion. The claimant's failure to refer to the preconditions for group treatment was only occasioned by the lack of time, but we submit that we do satisfy the preconditions for group treatment. And that brings me to the end of my rebuttal.
Thank you very much. Thank you, Council, for both on the preliminary issues A through C. With everyone else and my colleagues' permission, I think it's time for us to move to claimant on issues D and E, having to do with the merits and the quantum. I believe you've asked for 18 minutes and one of rebuttal. Am I correct about that?
Mr. President.
Okay, please proceed.
Thank you. Mr. President and honorable members of the tribunal, as previously introduced, my name is Salaton David Lemayan, second counsel on behalf of claimants. In the next 18 minutes, I shall address this tribunal on the merits of the case, where we submit first under issue D that the respondent has violated the fair and equitable treatment standard found within Article 3, Subarticle 1 of both the Tyrea Kitoa BAT and the Tyrea Novanda BAT. Moreover, the respondent has unlawfully expropriated the claimant's investment contrary to provisions of Article 6 of these applicable BATs. Lastly, under issue E, we submit that the compensation that claimants are seeking under claimant's exhibit number 7 is not speculative in nature, and that the discounted cash flow method provides an appropriate method of valuation for calculating this compensation. Unless directed otherwise by this tribunal, I shall now proceed to make submissions under issue D.
Please proceed.
Thank you. Article 3, Subarticle 1 of the relevant bilateral investment treaties provides that each contracting party shall afford fair and equitable treatment to the nationals of the other contracting party. The fair and equitable treatment standard referred to by these bilateral investment treaties has been examined by past tribunals, including the tribunal in Waste Management versus Mexico, and again the tribunal in Pope and Talbot Incorporation versus Canada. These tribunals have unanimously agreed that the fair and equitable treatment standard lacks a precise definition. However, in the words of Judge Schwabel, in the MTD versus Chile case, the fair and equitable treatment standard encompasses various fundamental elements, a breach of which would then be a violation of the larger fair and equitable treatment standard. And these elements, in Mr. Schwabel's words, are legitimate expectations, the element of non-discrimination, the requirement of proportionality, good faith, and due process of law. It is our submission that in the present dispute, 3 of these elements have been violated by the respondents. These elements that have been violated include legitimate expectations, the principle of proportionality, and the requirement for non-discrimination. Now, turning to the issue of legitimate expectations, as properly observed by the tribunal in Thunderbird versus Mexico, the legitimate expectations of an investor arise when representations are made to such an investor by the host state, and that the investor relies on these representations when making an investment. The tribunal in Micula versus Romania further noted that assurances made to an investor by competent organs of a state shall comprise such legitimate expectations. At paragraph 3 of the Statement of Uncontested Facts, found at page 48 of the Record of Dispute, and more specifically the last 3 lines of paragraph 3, we see Mr. Anderson, the spokesperson for the Tyrian National Parliament, acknowledging that indeed claimants had shown interest to invest within Tyria, and that they had contacted Tyrian ambassadors within their country to find out about the investment climate within Tyria. Mr. Anderson went on to state that by the new media law, the respondent state would then do everything within its power to fruitfully collaborate with the claimants in future. These assurances have been reiterated at paragraph 5 of the Statement of Uncontested Facts, found at page 49 of the Record of Dispute, where we see that in her opening speech during a web conference hosted in Tyria, a high-ranking official of the Tyrian government promised the investor that the Tyrian Republic would do its absolute best to facilitate internet use in Tyria. We submit that investors relied on these assurances when making their investments. I invite this tribunal to look at page 13 of the Record of Dispute under paragraph 4 of the sworn affidavit of Ms. Said Parlante, who is the Chief Executive Officer of...
Can I interrupt for a second? You're quoting very broad assurances of cooperation and support. But I'm wondering why that would mean that an investor would have no expectation that the state would still would not regulate social media. It's one thing to say we support, it's another thing to say we are not ever going to regulate social media.
Thank you for your question, Mr. Arbitrator. It is not our submission that the respondent state should not have changed its legislation or should not have enacted legislation. It is our submission that, as was held by the tribunal in Mikula versus Romania at paragraph 672 of its final award, that assurances made by competent organs of a state would form part of the, and if considered by the investors when making the decision to invest, would form their legitimate expectation. The legitimate expectations of the claimants would then not be that the legal regime would not change, but that the respondent state would not act inconsistently. At paragraph 15 of the Statement of Uncontested Facts, Mr. Arbitrator, we see that by the promulgation decree, paragraph 15 on page 51 of the record of dispute, we see that by the promulgation decree, the respondent state gave 60 days through which the claimants were supposed to comply with the requirements of the algorithm. At paragraph 18 of page 52 of the record of dispute, and specifically the last line of paragraph 18, we see that the Minister of Media within TAIREA admitted the importance of allowing time for development and testing of the algorithm. Despite this admission, at paragraph 19 of the Statement of Facts, we see that the respondent state slashed the compliance period from 60 days to 45 days.
So just to clarify, the legitimate expectation argument is focused on the cutting of the time period in order to implement the algorithm. It's not a more general basis to attack the legislation itself, but the change in the legislation once it was promulgated. That's your position.
Indeed, Mr. Arbitrator, that the claimants recognize that the respondent state reserves the right to legislate, but that it should not be inconsistent, because as was held by the tribunal in Saluka versus Czech Republic, inconsistent conduct of a state stands in the way of proper planning and confuses the investor. A culmination of that, as can be seen in this present case, would be a frustration of the claimant's legitimate expectation.
May I follow up on that just briefly? If there was complete war in the streets during that 60-day period, and the algorithms had not yet been completed, and therefore hate speech was proliferating on all the forums, not just the claimants, but the others, and the government decided that it just simply couldn't allow the same level that it had initially prescribed, would that have been a violation of fair and equitable treatment?
Thank you for your question, Mr. President. As you have correctly pointed out, Mr. President, if that had been the situation within TAIREA. However, that is not the situation within TAIREA, and therefore the respondent government should not have slashed down the period, therefore frustrating the claimant's legitimate expectations. I shall now turn to the element of non-discrimination. As was observed by the tribunal in ADC versus Hungary, discrimination arises when one party amongst several parties engaged in the same business and under the same circumstances is afforded different treatment. As can be seen under paragraph 13 of the Statement of Uncontested Facts, found within page 50 of the record of dispute, and specifically the fourth line of paragraph 13, claimant social networks were not the only social networks operating within TAIREA. There were two other platforms, Truthseeker and Wink, which was state-controlled. At paragraph 22 of the Statement of Facts, we see that radicalist communities also used these two other platforms. Now, the respondent state at paragraph 21 of the Statement of Uncontested Facts blocked the claimant's platforms and left these two other platforms operational. At paragraph 22 of these facts, on page 53 of the facts, we see that the respondent state did not offer an explanation why it did not block Truthseeker and Wink. We submit, therefore, that such behavior amounts to discrimination and is a violation of the fair and equitable treatment standard. Now, turning to the issue and the principle of proportionality, we submit that as observed by the tribunal in TechMed versus Mexico, the principle of proportionality demands a relationship between the means employed and the objectives sought. in their response to the request to arbitrate found on page 24 of the record of dispute, and specifically paragraph 7 of this response, the respondent have submitted that the objectives that they sought was to deny their citizens access to platforms where negative information was being disseminated. Page 9 of the record of dispute outlines provisions of Article 117 of the Tehran Penal Code, which provide for measures which the respondent state should take in the event that a social network does not comply with the requirements of Article 51 of the amended law. Now, these measures are first, an imposition of fines in the amounts of 50,000 to 100,000 in Tehran currency, or secondly, a temporary or a permanent blocking, depending on the possibility to cure the transgression. We submit that had the respondent state temporarily blocked the claimant's platform, it would have allowed the claimants enough time to test the algorithm in the field and provide a fully functioning and effective algorithm. In current practice, for measures of blocking by a state to be regarded as temporary, they must be accompanied by a specification of the period during which such a ban would be in effect. In India, for instance, the government blocked 22 platforms in the province of Kashmir from 26 April 2017 for a period of 30 days. After this period had lapsed, the government lifted the ban. Similarly, in Sri Lanka, very recently, on 21st April through to 30th April 2019, the government blocked Facebook. After the period specified of 1 week had lapsed, the government lifted the ban. In the present matter, the government has not communicated, as can be seen under paragraph 4 or on page 62 of the record of dispute, even when sought by claimants to further seek assurances about the blocking and further direction. 528 days later, Mr. President, the government has not given any communication on this blocking, and the government has not lifted the ban. We submit that these measures are therefore disproportionate. And this concludes our submissions on the violation of the fair and equitable treatment standards. I shall now turn to address the issue of expropriation. By violating the fair and equitable treatment standard, the respondent unlawfully and indirectly expropriated the claimant's investment. Through the enforcement of the Tehran Communications Authority Ordinance dated 2nd March 2018, found at paragraph 15 of the Statement of Uncontested Facts on page 51 of the record of dispute, the respondent state blocked the claimant's platforms, thereby causing the claimants to lose their revenue streams. At paragraph 7 of the Statement of Uncontested Facts, found at page 48 of the record of dispute, we see that the claimants earned their revenue through two main ways. First, the sale of advertising space, and secondly, the promotion of personalized content. It is impossible for the claimants to either sell advertising space or promote personalized content on a blocked website. Now, the tribunal...
May I ask you though, in an expropriation, what is it that the government actually took? Did the government take advertising revenue, or did it take the actual functioning of the social media forum?
Thank you, Mr. President, for your question. Now, in answering your question, I would like to, the tribunal in Middle East Cement Shipping versus Egypt held that measures by a host state which deprive an investor of the use or benefit of or benefits arising from its investment, even when the claimants would retain nominal ownership of the respective rights to their investment, constitute indirect expropriation. Similarly, the tribunal in CME versus Czech Republic observed that measures by a host state which leave the investor with only physical assets, but without an operation of business, amount to indirect expropriation. In the present dispute, as the respondents have correctly pointed out in paragraph 7 of their response to the request to arbitration, claimants' physical assets within Tehran are still intact. As I have previously submitted before this tribunal, the claimants cannot have revenue streams from these investments, and therefore measures by the state constitute an indirect expropriation. Further still, Article 6 of the bilateral investment treaties sets out conditions which must be met for an expropriation to be deemed lawful. These conditions are that first, these measures must be taken for a public purpose, they must be taken in a non-discriminatory manner, and that they must be accompanied by adequate and just compensation. I have already submitted before this tribunal that the respondents' state measures were of a discriminatory nature. The respondents also have not made any attempt whatsoever to pay any sort of compensation to the claimants. The expropriation is therefore unlawful. The respondents in their response to the request for arbitration have submitted that the measures that they took were within the framework of its police powers. We contend that such a defense cannot stand. For measures to be rightfully within the doctrine of police powers, they must satisfy several conditions, as was observed by the tribunal in Philip Morris versus Uruguay at paragraph 305 of its final award rendered in 2016. That these measures must be taken for a public purpose, must be taken in a non-discriminatory manner, and must be proportionate. We have previously submitted before this tribunal that the respondent state measures were disproportionate and that they were discriminatory. Therefore, the respondents should not be allowed to argue this defense.
Thank you.
Having submitted that there was an indirect expropriation, we submit that its corresponding duty is adequate and just compensation, as was held by the tribunal in Amoco Finance International versus Iran. This brings us to our final submission under issue E, that first, the compensation amounts that we seek are not speculative in nature. As can be seen under page 17 of the record of dispute, for the past 3 years, each of the claimants has enjoyed a consistent profit margin. Therefore, the projections that they make for the year 2018 are not speculative, but instead are reasonable and valid. Mr. Alonso, the claimant's expert, has also discounted these amounts at a rate of 5%. We submit that this rate properly reflects the risk that exists within TIREA. I would like to invite the attention of this tribunal to page 14 of the Statement of Uncontested Facts found under page 50 of the record of dispute. We see that, unfortunately, at the beginning of 2017, there were ethnic clashes within TIREA. However, if at page 17 rather of the record of dispute, we see that these unfortunate incidents notwithstanding, at the end of 2017, each of the claimants registered a double profit. Therefore, since this tension has remained the same, the risk should also remain the same, and that the respondents should not be allowed to argue that the compensation sought is speculative. The claimants urge this tribunal to adopt the discounted cash flow method in calculating such compensation. The discounted cash flow method has been defined by the World Bank Guidelines on Foreign Direct Investment, the 1992 World Bank Guidelines on Foreign Direct Investments, under Section 6, to be appropriate for enterprises which are a going concern. The guidelines have noted going concerns to be enterprises with a proven track record of profitability. We have already submitted before this tribunal that each of the claimants has a proven track record of profitability. Previous tribunals have adopted the discounted cash flow method when the enterprises that appear before them are going concerns. For example, the tribunal in Total SA versus the Argentine Republic adopted the discounted cash flow method. Total SA had been an investor within the Argentine Republic and had lost its investment through expropriatory measures by the state. Again, the tribunal in Starrett Housing versus Iran adopted the discounted cash flow method based on the fact that Starrett Housing had been a going concern within Iran. In light of the fact then that each of these claimants is a going concern, we urge this tribunal to adopt the discounted cash flow method. And if there are no further questions, the claimants would like to conclude their case.
I do have a question. One of the heads of damages that you're seeking relief for relates to expansion to other markets. And I understand, though, that you're not using going concerns in those markets as a basis for claiming damages. What basis do we have to take the approach that we're taking for TIREA for those markets in which your clients have not yet invested?
Thank you, Mr. Arbitrator. I would like to turn to invite the attention of Mr. Arbitrator to paragraph 3 of procedural order number 2 on page 62 of the record of dispute, where we see that previous expansion efforts by each of the claimants have been successful by a percentage of 35%. As can be seen also in the statement of facts, the neighboring countries which TIREA which the claimants want to expand to are neighboring countries of Tyria. Therefore, the markets are similar, and that the expansion profits that we seek under Claimant Exhibit 7 are not speculative. I will now state the reliefs that we seek from this honorable tribunal. In light of the arguments made and the authorities invoked, we urge this tribunal to find that, first, to not grant the provisional measures that the respondents are seeking. Secondly, that this tribunal shall find that it indeed has jurisdiction over this matter, despite the respondents' denunciation of the Exit Convention. That this tribunal shall find that it has jurisdiction over the multi-party claim brought before it. That this tribunal should find that the respondent state has violated the fair and equitable treatment standard and unlawfully expropriated the claimant's investments. Finally, we request that this tribunal finds that the compensation that we seek under Claimant's Exhibit 7 is not speculative in nature, and that the discounted cash flow method is the appropriate method for calculating such compensation. This concludes the claimant's submissions. We thank the tribunal for its time.
Thank you very much, counsel. As I recall, you have reserved 1 minute for rebuttal. So let's turn now to, I'm sorry, was there something? Okay. Then let's turn to counsel for respondent and ask you to please address the merits and the quantum issues that have just been submitted to us.
Mr. President, members of the tribunal, good afternoon. By way of reintroduction, my name is Joy Mvati, fellow counsel on behalf of the respondents, the Republic of Tyria. The respondents wish to make 3 key submissions touching on the merits of this dispute and in response to the claimant's allegations. These submissions shall touch on A, that the respondent has not breached Article 3.1 of the relevant BITs, B, that the alleged expropriatory measures alleged by the claimants are not applicable in this instance, and C, that the valuation method being proposed by the claimants is too speculative to be used, and therefore the more objective cost-based valuation method should be used in this regard. Concerning the first tier of our argument, that is on the fair and equitable treatment standard, page 55 of the record contains the operative provision, wherein it prohibits a state from taking measures that impair the investments of a national in a manner that is unreasonable or discriminatory. It is in light of this that the respondent submits that the measures were first, not arbitrary, not unreasonable, and secondly, not discriminatory. With regard to the first tier of our argument on reasonableness, the claimants have alleged that our actions were unreasonable as they violated the legitimate expectations of the claimants. However, we submit that on the basis of this tribunal's prior decisions, legitimate expectations in the manner in which the claimants are alleging cannot be deemed legitimate. The claimants have alleged that the words of the Tyrian spokesperson of Tyria, Mr. Anderson, gave rise to a legitimate expectation on the part of the claimants. However, the standard of legitimate expectations by assurances by the government must fulfill the threshold of specificity. In the tribunal decision of Clorinex versus Venezuela in 2015, the tribunal determined that government assurances must be sufficiently specific in that it must guarantee first that it is targeted exclusively to the investors in question, and additionally, that the respondent specifically adduced the fact that it would not exercise its right to regulate. This is submitted based on the facts of this case and based on Mr. Anderson's words was not the case. It addressed generally investors of Tyria, although it included the claimants. However, it was general to every investor in Tyria operating in the social media era. Additionally, the claimants were not guaranteed that the respondent would not exercise the right to regulate, even if it impaired the investment of the claimants. If the claimants had wished to secure the investments in a more suitable manner before this tribunal, then we submit that pursuant to the 2007 decision of Parkerings versus Lithuania, for such protection to be recognized, it must come in the form of a stabilization clause or a specific contract between the investor and the respondent state. If the tribunal has no further contentions or the legitimate expectations argument, would wish to proceed to the alternative argument on discrimination, which is the second limb of our argument.
I do have a question on legitimate expectations. A similar point is that there is a relative lack of specificity in the declarations or the representations that the claimant's relying on. Isn't it fair, though, for us to look at the measures taken, and in particular, the measures taken with regard to the timing for the algorithms and other steps required by this regulation, and judge whether or not those are consistent with the types of representations that have been made here?
Thank you, Mr. Arbitrator, for your question. The claimants have brought out the point that the measures undertaken by the state, subsequent measures, had the effect of depriving the value of the investments. However, the same issue came before the Exit Tribunal in the 2007 decision of Sempre Energy versus Argentina in the wake of the economic crisis that plagued Argentina in 2001. And the tribunal had this to say regarding the reasonableness of the state measures, that in the context of a crisis, the tribunal should not rule on the merits, or rather whether the measures undertaken were necessarily good or bad, but rather whether at the time of these measures, the claimants were aware of the situation that necessitated the actions being taken. And therefore we submit that on the basis of this fact, the measures undertaken were against the background of a social crisis undergoing in Tyria. There were people dying, and according to paragraph 14 of the record of facts, this was to the hundreds. Therefore, the state's measure of rather reducing the deadline of compliance was in response to this aggravating situation, which the claimants would have been perfectly aware of, being willful and prudential investors.
May I follow up that with just one question? The other restriction had to do, or the other regulation had to do with requiring that the names and contact information of all users be provided to the government. What is your argument as to why that was a reasonable and reasonably necessary under the circumstances?
We submit that the requirements to issue personal ID card details was indeed reasonable in the circumstances. According to paragraph 13 of the record of facts in page 50 of the general record, it is stated that these extremists had sought the claimants' platforms in particular because of their wide reach and created profiles to sort of disseminate misinformation. Now, one of the factors that attracted these extremists was the aspect of anonymity. Now, if we were to exactly pinpoint who exactly is disseminating this hate speech, the respondent believes, or the respondent contends, that the information of who exactly is behind this misinformation would be required. Now, according to page 8 of the record, it contains the general requirements to issue the details to the government, but also it states that the personal ID card details generally will be protected by the Tyrian law on data protection. Therefore, we would only require this information if it was sufficiently necessary to determine who was spreading this misinformation. If the tribunal has no further contentions, we would wish to proceed to the second limb on discrimination. Now, the claimant contends that because the domestic investors and the foreign investors were in a comparable situation, that is, the extremists used all of their platforms, then the blocking of the claimant's websites to the exclusion of the domestic ones was discriminatory. However, the respondent contends that this is not to be the case. According to the 2006 decision of Seluka versus the Czech Republic, the tribunal determined that for a measure to amount to discrimination, it must be such that the state did not offer a reasonable justification based on the whole state's law. According to Article 51 bis of the record, that's the amended Tyrian law on page 8 of the record, Article 51 bis, and specifically clause 1, states that the effectiveness of the algorithm shall be tied to factors such as the website's audience size. Now, the respondent submission as regards Wink was that their spam messages were out of the filtering algorithm's reach. We submit that this was a reasonable justification based on the requirements of Article 51 bis, Clause 1. And in this light, the claimants ought to have regarded in the development of their filtering algorithms the fact that their wide mass of reach required more stringent requirements as to the filters, especially with regards to Wink and TruthSeeker that had less popularity and a less audience size.
I'm concerned about this argument because it seems to create a circularity. If the legislation targets in a discriminatory or non-discriminatory way, but targets a certain company, and then we're measuring the reasonableness about how well it then complies with its own target, aren't we supposed to judge whether or not targeting larger, more successful companies or foreign companies is discriminatory? And are we allowed to take into account, for example, that there was no time to continue to work? So if one of these companies was able to say in 3 weeks or a month, we've now fixed this, they have no recourse under the legislation. And can we say, well, that is not a reasonable way to accomplish the goals, even if we accept the goals are in the public interest or otherwise reasonable?
Thank you, Mr. Arbitrator. With regard to your first question, the respondent actually agrees that if we were to truly regard this as a comparable situation, then we would have to accord that similar treatment to more popular websites. However, the claimant's specific allegation is that the respondents discriminated against them because they were social media networks, all under the amended Tyrian law, and that despite the fact that they were all being used by the extremists, that the claimants in particular were blocked. However, we submit that it is because of this popularity that the claimants' websites were indeed blocked. With regard to
No problem. I was just scratching.
Could you please, Mr. Arbitrator, could you please unmute? We can't hear you.
Sorry. Oh, sorry. Isn't what you're saying in some ways the essence of discrimination? You're saying the legislation and the way the government implemented the legislation was choosing between different companies in the same general sector. And if you're going to make that choice, don't you really need as the government to come up with some compelling reason why you would treat these companies differently when you say the harm is applicable to all, or is arising from all these companies? Why are these companies being treated differently?
We submit that the reason why these companies are being treated differently is because of the mass reach within the claimants have interior. According to paragraph 10 in page 50.
But let me simplify it. Why isn't the right and a fair and non-discriminatory legislation applicable to everybody and not just the ones who are more successful? Isn't it this inherently discriminatory?
We submit that it's on the basis that the claimants specifically did not comply with the amended Tyrian law, and this applied to all social media networks operating in Tyria. It was not discriminatory against the claimants, as it was a general regulatory measure applying to all social media.
Well, has it been applied the same way to all social media companies?
Yes. The legislation in itself was not discriminatory. I didn't ask about the legislation. Now I asked about the application of the legislation. The application was not discriminatory because according to the Saluka decision, for an action to amount to discrimination, it must be in the absence of a reasonable justification by the state, and that justification must be tied to the domestic law of the state applying to the investors at that time. And we submit that on the basis of Article 51 bis, that applied to every social media network, the audience size of the website was a factor to be considered in implementing effective algorithms. And therefore, the claimant should have taken this in regard in implementing those algorithms, and therefore, Wink's alleged inefficiency was not to be compared with that of the claimants, as they had a lower reach. If the tribunal has no further contentions, we would therefore wish to conclude that the actions based on the Tyrian law were not discriminatory, and neither were they unreasonable. We would therefore wish to proceed to the second tier of our argument on expropriation. Now, the claimants allege that pursuant to Article 6 of the BITs, that the respondent's actions led to an expropriation. However, Article 6 only relates to actions of indirect and direct expropriation, of which the respondent's measures did not amount to. The tribunal has in fact regarded a legitimate exercise of regulatory powers as an affirmative defense to claims of expropriation. In the 2010 decision of Suez and Interaguas versus Argentina, it was stated that the successful implication of a regulatory power would mean that the civil liabilities coming from an alleged expropriatory measure are extinguished. In this light, we would wish to proceed to the argument that on the second tier, that the substantial deprivation has not been fulfilled, that renders a regulatory power as an expropriatory measure. With regard to the second tier of our argument on substantial deprivation, we submit that the distinguishing factor between indirect expropriation and regulatory power is that in which effectively neutralizes the benefits of the investment. This was the tribunal's determination in the 2007 decision of LG&E versus Argentina. Now, what does this effective neutralization mean? The tribunals have interpreted this in many decisions, including Tidewater versus Venezuela in 2015, but more importantly, Pope and Talbot versus Canada in 2000, to mean that there must be severe interference with the investment of the claimants. This would mean that the claimants would have to show that the effect of the expropriatory measure would be such as to interfere with the internal operations of the claimant's investments, the internal operations of the shareholders of that investment, or the appropriation of the revenues by the state for their own use by the state. And we submit that based on this interference test, this has not been fulfilled, and therefore it cannot be said that there was a severe interference with the claimant's investment. Now, the claimants have also brought forth the point that the loss in profits of the investment is a factor to be considered. However, the tribunal's decision in 2011 in the decision of El Paso versus Argentina was to the effect that the loss of profits cannot be a criterion to determine substantial deprivation, and that the effective test is that of interference with the investment. If the tribunal has no further contentions, we would therefore wish to conclude that in the absence of the claimants establishing that there has been substantial deprivation through interference with the investment, then it would follow that there has been no expropriation to be found by this tribunal. I would therefore wish to proceed to the final limb of our argument, that is on the valuation method to be used by this tribunal. The claimants, through their expert's opinion in page 13, propose the discounted cash flow analysis method. However, we submit that for the tribunal to use this method, it must first be ascertained that the method is not speculative. And this is the arms of our argument. That first, the discounted cash flow analysis method is too speculative, and second, that a more objective valuation method of cost-based valuation should be used. I see that my time is quickly running out. I therefore wish for an extension of 2 minutes, to finish the argument on compensation and thereafter state our prayers.
It is granted. Go ahead, please.
With regard to the first tier of our argument, that is on speculativeness, it must be regarded by this tribunal that pursuant to the fact in page 62, paragraph 2, that the claimants have not submitted business plans to substantiate the values being put forth by the claimants. Now, this would be an important omission that this tribunal should regard as mitigating against using this method, and this was the case in the 2005 decision of ADC versus Hungary, whereby stated that the ideal form of using the DCF method must be with the according of business plans. Now, another factor that leads to the speculative nature of this method is the discount rate being proposed by the claimants. The weighted average cost of capital has two components. that is the risk-free interest, as well as interest rates that accord certain risks that include the country risk premium. Now, this is an important consideration because the situation in Tyria was a particularly volatile one. As we stated, there have been lives lost and a situation in which there has been general instability and a threat of civil war. Therefore, there must be a discount rate that is merely higher than a low 5%. And whatever this tribunal may use, we submit that in either way, 5% is too low. And this was found to be the case in St. Gobain versus Venezuela in 2016, where it found that the country risk premium to be accorded is an essential requirement in determining the weighted average cost of capital. Now, with regard to the second tier of our argument, we therefore submit that, bearing in mind the speculativeness, that a more objective method should be used by this tribunal owing to a perceived reluctance to adopt the discounted cash flow method, and this should be that based on the proven expenditure by the claimants. The tribunal in Rusoro Mining versus Venezuela in 2016 used the method of actual investments because it was a more objective valuation. And therefore, we would conclude that the discounted cash flow analysis method is not the appropriate method. Therefore, the prayers that the respondent seeks are as follows. First, that the provisional measures should be granted to the respondent state. Secondly, that the jurisdiction of this tribunal does not extend in this instance because the respondent has denounced the exit convention. Third, that the tribunal additionally does not have jurisdiction over multi-party claims in this instance. Fourth, that the state did not violate Article 3.1 and Article 6 of the BITs. Fourth, that the discounted cash flow analysis method should not be used by this tribunal as it is too speculative to be used in this regard. Thank you.
Thank you, counsel, very much. I believe now we have a rebuttal from opposing counsel, and I think it was 1 minute that was reserved. Am I correct?
Yes, you are, Mr. President.
Please proceed.
Thank you. The claimants would like to rebut on 3 points submitted by the respondents. First, counsel has alleged that legitimate expectations of the claimants were not frustrated because there was not specificity. However, I direct the attention of this tribunal to page 48 of the record of dispute and specifically underline 1480, where we can see Mr. Anderson clearly calling out each of the claimants by name. Secondly, the counsel for respondent has submitted that the measures of the respondent state were not discriminatory because the two other platforms were not blocked because of compliance of the law. I direct the attention of this tribunal to paragraph 22 of the statement of facts on page 53 of the record of dispute and underline 1630, where we see that the Tyrian Communications Authority explained the lack of blocking by stating that the other social networks were less popular and less convenient. We therefore see that the respondent state was, as a matter of fact, punishing the claimants for being popular. Finally, counsel for respondent has submitted that there was not substantial deprivation. I guide this tribunal to page 15 of the record of dispute and specifically underline 175, where we see that talks between the investors and the neighboring countries stopped because of the respondent's measures. We therefore submit that, as a matter of fact, there has been substantial deprivation. This concludes our submissions. Thank you.
Thank you, counsel. I think our last presentation will come by rebuttal from opposing counsel. Please proceed.
Thank you, Mr. President. The claimants have proposed a line of argument that in the respondent's contention is problematic. And therefore, it is submitted that the claimant's arguments have more holes than Swiss cheese. It has been submitted by the claimants that on the first bit of legitimate expectations, that they still arise because of the specificity of the respondent's assertions. However, it is important to note for this tribunal that the assurances by a government official cannot be deemed to arise to legitimate expectations as they cannot bind future governments and therefore fail to meet this threshold. With regard to the argument that the respondents or rather the domestic websites were not blocked and therefore were discriminatory, we submit that on the basis of the fact these measures were not discriminatory, and particularly in the case of TruthSeeker, we are told that in paragraph 13 in page 50, that they had a self-correcting mechanism for the spread of misinformation. Therefore, these measures were not to be undertaken with prejudice to the claimants. With regard to the argument on substantial deprivation, we wish to submit that the loss of value of investments cannot, in the absence of showing interference, amount to substantial deprivation, and this was the tribunal's determination in the 2011 decision of El Paso versus Argentina and Pope and Talbot in 2000. Therefore, with these errors in their arguments, we therefore wish to implore this tribunal to adopt our line of argumentation. Thank you.
Thank you, counsel, all. I believe that brings the presentations to a conclusion. Counsel, I just can't tell you what a wonderful job you've done and how enjoyable it has been to have the privilege of participating in it. I know I see some nods from my colleagues, so I'm, forgive me, I'm turning off the timer. So that you're aware, what we now do is we are going to leave this meeting and we are going to confer. I think Professor Campbell would like you all to remain in the meeting, though obviously you're and feel free to move about or rejoin it. I don't know how you'll know to rejoin us if you don't stay connected. So we will now depart and confer among ourselves and return to you hopefully within a short period of time. Colleagues, am I okay with that? Shall we break? Great. Thank you all very much. We'll be back to you.
Thank you, Joe. I think they're somewhat optimistic if they believe it will be easy to arrive at a decision. Just let me go through a few housekeeping notes while they're away. First of all, as you know, the winning team today will receive a US dollar 1,500 prize, which is sponsored by Wilmer Hale. And the best advocate of the final will receive a USD $500 prize, which has been sponsored by an anonymous donor on behalf of the International Academy of Trial Lawyers. So that's part of what they're going to have to decide now, and that's why it may take them a little bit longer. I also want you to know that Three Crowns LLP, which is an international arbitration boutique based in Washington, D.C., but with offices in London and elsewhere, has donated $3,000 to the Velde Fund, which we will try to distribute fairly and equitably among the top 3 teams, so today's finalists and the 3rd place team from yesterday. And in the context of that sponsorship, Three Crowns Managing Director Hugh Carlson, one of the partners, Agustin Sanz, and another colleague, Mihir Chattopadhyay, have offered to supplement the winning team's coaching to the extent that you'd like to have that by doing practice hearings with you over the coming weeks. So if your coaches, because I can tell that you already have excellent coaches, are interested in that, I'll put you in touch with the Three Crowns arbitration team, and you can coordinate something if you'd like to. Okay. And one last housekeeping point, because a few people have complimented the case and said that it's a very good case this year. And I think it is a very good case this year. So I want to give some acknowledgement to the team that put the case together, which I think you can now see on your screens. These are some FDI Moot alumni, some of them from 5, 6, 7 years ago. One of them, an alumni from last year, who were working on the case starting last summer and are right now working on the responses to the second round of clarification requests. So I think any credit for this year's case goes to them as its authors. I personally think they've done an excellent job on that. And with that, we'll wait. Any questions from your side? Brownlee or Lalonde, any questions?
None from our side.
None yet. Okay, we'll wait. Thank you. The arbitrators will be returning in just a moment. Just have all your attention. They're on their way back in, so to speak.
Okay, I think we have everyone back together. And so, as we come back together, I'd like to once again tell you that my colleagues and I could not be more sincere in telling you, all of you, that you were just wonderful. It was a privilege, and it was extraordinarily difficult. The discussions we had and the decisions that we will announce in a few minutes. I'm gonna ask my colleague Stephen Brunza to go first with the comments, and then Wilson, and then I may have a few after that. So, Stephen?
Great. Look, as Joe said, you all did remarkably, spectacularly well, and you made our deliberations extraordinarily difficult, and you should all feel extraordinarily proud, not only to have gotten to the finals, but to have performed so well. I'm gonna give you a few comments that are meant to be constructive. So I'm not gonna spend a lot of time complimenting you, because you're here because you're really good and you did a great job. So a couple of observations about getting better. The one thing I think across the board that I would like to see you do as you go forward is to be a bit more affirmative. A lot of times in stating your case, and stating your case quickly to us, a lot of times you were academic and you were setting out the standard and the law first. And particularly, I think always, but particularly in a setting like this where we only have a few minutes, making sure that you're really articulating your client's best position early on, and then supporting it with the law and the standard, I think would take you up another level. And I think you all did that at times, but to consistently do that, I think is the next step. And I think there was, everyone was very organized. There were really good roadmaps and explanations of where you were going. Sometimes you spent more time telling us where you were going than you needed to, rather than taking the precious few minutes you had to deal with making more substantive arguments. So get that balance right. And I think, I guess lastly, you all were very cautious, careful, clear, planned speakers, occasionally a little bit more passion. I would have liked to have heard a little bit more about the freedom of expression issues here. I think the claimant could have grabbed hold of that and made more use of it, and the respondents should have expected that as well. But overall, I mean, I'm nitpicking because these were really well done across the board by all of you, and therefore it's really hard to do more than make those sorts of points. So congratulations.
Wilson, you want to proceed?
Yep, let me proceed. Participants, thank you very much for the kind of presentation that you've had. We had a very difficult time deliberating between the two teams, and in fact, it was like a hairline decision in choosing the winner. But in actual sense, there is no winner, because this is a learning process. And as Stephen has said, the issue here is practicality, because you're representing the client. If you're for the claimant, your client is the claimant. So put forward your case, and the same case for the respondent. So, and I wish you all the best in the next round, and I'm hoping to meet some of you in practice again. So congratulations, all of you.
Thank you both, and again, thanks for to Professor Campbell for allowing us to serve as this this tribunal. A couple of modest comments. I don't think there's much doubt that the responsiveness to questions and the ability to draw the knowledge of the law and and apply the facts to it in response to questions was astounding, and was ultimately the determinative factor in our discussions. A couple of minor things you might think about. Each time a question is posed, you don't have to say thank you for that question. You can do it obviously the first time, and then try to figure out a shorthand way of doing it from then on. And there are other modest stylistic things of that sort. But overall, the ability to understand the law and the record facts, and to engage us with our really interesting issues was just superb. And that's what you need to keep working on and keep getting better and better at, because you've got a great foundation, all of you, in that regard. With that said, it is my privilege and obligation, and it's difficult, but I'm going to announce the team winner and the best oralist. The team winner, we concluded, was the Claimant. I believe I'm going to brag on Steve's firm, Wilmer Hale. It's one of the finest law firms in the world, and certainly in this part of the world dealing with international arbitration, and they have generously provided the prize for the winning Claimant team. And with respect to the best oralist, again, an incredibly thin line between all four. We concluded that Claimant's number 2 was the best oralist on this day. I've been a trial lawyer for 42 years, and I can assure you that on any given day, I have perhaps sometimes been determined to be the best, and oftentimes determined not quite to have been the best in the room. So every one of you can and will be given that accolade at some point soon in your careers, and probably often. I'm very proud that the International Academy of Trial Lawyers and my dear departed friend Noel Ferris have provided the prize for the best oralist. Once again, let me just tell you what a wonderful experience it's been for me. I do get to Africa, not regularly, not nearly as often as I'd like, but the next time I'm planning on getting in contact with Professor Campbell and making certain that I can meet as many or all of you as is possible to meet. And I will definitely be in Miami in November. It's my hometown, and I intend to show it off to all who will come and participate. And last but not least, my alma mater, the University of Miami Law School, will be the host. And so I will look forward to any and all of you who are able to come and participate. My colleagues, anything else that we should want to cover? Steve?
Just again, congratulations. And I see glum faces with the respondents, and I have to tell you, everyone, this was razor thin. You all did spectacularly well, and it was so close, and you should feel like winners, even if you didn't get the nod today, because it was that close. And you all did fantastic, and you all will move on from here in undoubtedly a great way. So congratulations.
Wilson?
Congratulations to the winning team, and for the team that didn't make it to the second round, to the other round, they still this is a learning process, so keep on the drive. Thank you.
I believe that's it, and I think that it is my privilege to adjourn the proceedings, though I'm hopeful that Professor Campbell is in the background, and if any of us have forgotten something, that he will jump in. Failing to hear anything, oh, there he is.
I'm here. I don't think we've forgotten anything. I don't know if the teams want to say anything briefly. Express some relief that it's over, at least for a little while, though we hope that they'll both be in Miami. And for the runner-up, there's always the hope that the tables will be turned. That's how it is in life and in moots. So if the teams want to say anything, I'd welcome them to do that perhaps, and otherwise we can.
Mr. Campbell, and
yes,
our very, very nice arbitrators, we'd like to thank the competition for this opportunity to learn and to participate in this competition. We are, of course, very excited that we have won this round. We are aware, however, that there is a bigger challenge at the global stages, and we shall continue to prepare well. We want also to congratulate Team Brownlee because they put up a very good fight, and we were very scared as well as we waited for the results. And so, yeah, to sum everything up, it has been a wonderful experience, and we cannot wait to be part of this competition again at its global stage. Thank you.
Thank you very much.
On our part, I think we should also thank the arbitrators for this round and pass our congratulations to the winning team. Thank you.
Thank you very much. We will hope to see you both again, perhaps in a semi-final or maybe even a final in Miami. Who knows?
Yeah, Professor Campbell, if I could offer, if any of the participants want to reach out to get further comments from me, certainly by email, I'd be happy to.
I think we've lost his
audio,
but
sorry. So people want to email me for further sort of specific feedback from both teams. I'm happy to give further feedback offline.
Fantastic. I'll share your email with them, and then you can do that. Thank you very much, Stephen. Thank you very much, Joe, Wilson, to both teams, and I'll be in touch with the teams by email as well now.
Great.
Thank you all. Have a wonderful weekend.
Thank you again very much. Bye-bye now. Yeah, absolutely.
Thank you, guys. Wonderful. Thank you, Wilson.
Okay, bye.